Call the meeting to order at 3 p.m. Our first agenda item is a review of the minutes from October 18th. Do I hear a motion to approve those minutes?
So moved.
Great,
I'll second.
thank you. Any discussion on those minutes, changes, amendments, errors, omissions?
Spelling errors.
Oh yeah, I got some for you.
Really?
Yes. Okay. Under the section headed public comments, about halfway through there, there's a typo. It said committee would S well. You see what I'm saying?
Yeah,
Okay.
as well.
As well.
It's actually slang.
Swell.
Swell. We're swell.
Yeah.
And
Right
then-
in that same spot, his name? I think his name has an extra A in it. As Al-Janabi, or her name, Sarah Al-Janabi. I think it was just one A.
I thought I used the, I can check on that. I
Okay.
thought I used the printout to
Okay,
get that
great.
because I couldn't spell it. Anyway.
Then maybe I've misspelled it.
So we'll check it. Where else, Rebecca? Come on.
No, the only other thing I was going to do is not a typo. It's just in the subcommittee part where it has that I will author the final report. I just felt a little uncomfortable with that because I feel like this committee is authoring the report.
You trying to clarify my minutes?
She's gonna edit it.
I don't think you can clarify my minutes.
I'm not getting involved in
We
this.
all. I just feel like it's awkward for me to sound like I'm authoring it.
Sure.
So I'm
You're
just pulling
not?
it together.
Would
I mean,
you like, we'll write the final report?
sure. I don't know. Is that all right?
It's your report.
It's not my report. I put it on the record. It's our report. Our report. Anyway, that was it.
Great call.
She's gonna compile
Draft. There you go. That's a better word.
That's why we got her.
Great.
Draft for review and approval by the committee.
Any other discussion on the minutes? Great. All in favor of approving the minutes as amended? Any opposed? Any abstentions? Wonderful. We will accept the minutes of October 18th as amended. Second agenda item, review of public comments. We do have one additional public comment that came in this week. I had sent it to you all recently. The comment is from Edward Donis. Edward says, I am very concerned for allowing non-citizens to vote. As we all know, this country is built on immigrants that came here legally and became citizens. They sought a better life to escape poverty and be free from oppression. My grandfathers are just one example. They came here for the same reason. One left Ukraine by himself at the age of 14 and arrived here in 1901. The other left Poland by himself and arrived here in 1899. Both were processed at Ellis Island. In that process, they agreed to and signed the U.S. Declaration of Intention to become a U.S. citizen. My grandfather from Ukraine worked hard as a boarder on a farm for 10 years. During this time, he saved enough money to buy a farmhouse and land. He then went back to Ukraine, married my grandmother, and they returned to the U.S. to farm and raise a family. My grandfather from Poland apprenticed here at a lumber mill, later bought the business, and became very successful in the lumber business. He married a Polish woman here, who also immigrated from his hometown in Poland. They both learned English, and in years that followed took the oath of allegiance and became U.S. citizens. So what has changed? Being a U.S. citizen meant you have vested interest and say in the government you vowed and signed in the U.S. Declaration of Intent, and then in taking the oath of allegiance. Why would this basic requirement and privilege to vote not be necessary for this generation, including town municipal elections? I have great respect for the present-day immigrants seeking the better life and escaping oppression. However, to those who see the importance of the right to vote, do as the generations before you and become a U.S. citizen. So I think we'll probably have agreement that we'll send this on to the voting group. Any other comments on Edward's comment to us?
Yeah, I just want to again state that I would be careful as people. I think that the general opinion at first glance is that we're considering non-legal people to vote, which we've adamantly and very clearly said that we're not considering illegal voters. We're looking at considering legal residents of Bennington who happen to be, as he mentioned, process was a big component of his email. They are going through the process, and in some cases we know this can take years and years, a decade. So while we're not here to argue that the immigration system, which has gone without remedy or upgrades for the last 3 decades, we're not here to do that. We're here to consider non-citizen voting in a scope that may or may not make sense. So we'll consider it and
Great.
follow up.
One other thing that came up for me as I looked at this comment, and a few of the others we've received too, is there seems to be occasionally people speak about voting as a privilege, and I want to just be careful about that too. Voting in this country is a right, not a privilege. This commenter refers to it later as a right to vote, but does previously refer to it as a privilege. And so I just want to make that point as well. All right. Any other discussion on this comment? Great. Voting group will take that under advisement. Next up on our agenda, discussion with council. We have with us today Meryl Bent, the town attorney, is that right?
Yep.
And we have a few questions that we provided to her in advance, some topics. So thank you, Meryl, for being with us today.
Yeah, thanks. Happy to help.
And I don't know if you have a thought about the best way to address this, if you have something prepared already, or...
I was just going to go through them in the order that they were presented to me. However, there are, as I mentioned in scheduling this, there are some that I did not have enough time to go through. So I was going to answer the ones I've been able to and identify the others that I am still working on. And then there were some that I could use some clarification on what it is that you're asking of me so that I can go back and make sure that I'm giving you what you want.
Yeah, that
Okay.
sounds great. I think as we go through, when we get to places that you're a little unsure of, we
Yep.
will have a brief discussion about
Perfect. Great. So do you mind then if I just start going through them and then people
Yeah.
can just jump in and
Yeah, that's great.
Okay. So the first, I think, there were a list of bullet points under the employment agreement section, which I viewed as actually secondary to the question that was below. So I'm going to start with the question that was below, which is, our charter states that the town manager may be dismissed without cause, but we've heard that this conflicts with state employment law. The doctrine of statutory construction would seem to indicate that the charter provision would prevail. Can you help clarify? And so this is a really excellent question. And Stuart, close your ears.
Take the notes.
You ain't gonna misspell anything here.
Oh, this will be good. I'm ready.
So it is true that whether the a legislatively adopted town charter or the statute is controlling is a matter of statutory construction. There's case law on point on that in Vermont. And that the provision that usually comes up, the statutory construction provision that usually applies, is where two statutes deal with the same subject matter and one is general and the other specific, the more specific statute controls. So under Vermont law, a town manager, there's actually a statutory provision that says a town manager shall hold office at the will of the select board, who by majority vote may remove him or her at any time for cause. And notwithstanding the fact that that statute both says at the will of and for cause, the Vermont Supreme Court has addressed this and construed that provision to require that a town manager be removed only for cause.
Okay.
However, that's the statute. So the construction of the statute, I'm going to get into a constitutional issue second, but so because the rules of statutory construction dictate that a charter provision that's more specific prevails over the more general statutory provision, a charter provision that's specific to Bennington that says something different would prevail over the statute that says for cause only. So if Bennington has a charter provision that says that the town manager may be dismissed without cause, that does prevail over the more general state statute that requires cause. So the can you help clarify section of that is that yes, the charter can override the statute to say that the town manager can be dismissed without cause.
Okay.
Does our charter say without cause? Or does it say after 90 days notice? I think it's silent on
Yeah, I
whether or
think
not
it's silent.
clause.
Can I,
Where is our charter?
and can I ask you a follow-up question to
Yes.
that? So how is it more specific if one states with cause and then the other one just states the opposite, which is without cause? How is that more specific?
My read of it is it's more specific because it specifically pertains to the town of Bennington.
So do we need to say the town manager of Bennington?
Nope,
In order, or
because
just the town manager?
The charter
in
provision would
charter?
only apply in the town of Bennington. Now, the other issue that this raises is that when you have a for cause provision in a statute or in a charter, it creates a property interest in the town manager's employment, which also brings with it constitutional due process protections such as notice and an opportunity to be heard. And I think that the default that most towns follow is that anytime you're talking about removal of a town manager, and actually other public employees, does require that notice and right to be heard process. And I don't think anybody has answered the question of whether that goes away if the for cause requirement goes away. So you would want to, you may want to further consider whether there's still a hearing process that should be applicable.
So the current
Okay.
process would suffice then?
Well, so two notes
Yep.
to the conversation. It does say without cause here. It says on 90 days written notice from the select board notice,
Right.
the town manager may be removed without cause by a majority of the select board at a meeting called for the purpose. And then town manager may within 10 days of such notice being sent request a hearing. The hearing shall be held. So there is notice, there
Yep.
is hearing,
Yep.
there's
So to the extent you're considering any change to that, you just want to keep that in mind, that may be a constitutional requirement.
okay.
So my understanding of the question is a charter provision that has a without cause, even though that conflicts with the statutory default, is that okay? And the answer is yes.
Okay.
Sorry.
That's okay. They haven't removed me yet.
Well, in fairness, we can't get any more heard than currently.
I'm not adding that to the
Good.
minutes.
Good idea.
I couldn't resist.
So then the other questions, the bullet point questions that I thought were related to this, and I'm a little unclear on what some of them mean, but experience with employment agreements, I presume you're asking if I have experience with employment agreements, but I wasn't sure about that.
So I guess the context here, which admittedly could have been clearer, is that this committee is considering recommending that the select board have an employment contract with the town manager
Okay.
instead of an at-will employment arrangement.
I see. Okay, and that is something that is typical in other towns. A lot of towns have. I don't know what Bennington has done historically, but a lot of
Never.
never. Okay.
Okay.
Some other towns do have an employment contract that they go through with town managers and town administrators.
Okay. I don't know if it's on here. One piece that came up in relation to this. Does the select board have this authority and option already without a charter change? So our current charter doesn't specifically speak to the ability of the select board to enter into an employment agreement, sort of a contractual arrangement with the town manager. Would they have that ability anyway?
They do have that authority. However, it needs to be consistent with whatever either state law or as amended by charter applies.
Okay.
So.
Is there an issue with, if we're gonna say that the specificity of without cause applies to Bennington, but we don't have the more specific language regarding the employment contract? Does that, the absence of both being specific versus one relying on statute, does that change anything?
I don't think so. And Dan and Stuart, if you want to jump in and say, well, what about, please feel free to do that.
So I think what the question is, and I think you may have answered it, but I just want to make sure that I understand it, is we have given the language in the charter. If
Yeah.
the select board said, you know what, I really want to get that guy from, let's say we want to get Dom down here from St. Albans, and it's going to take a 5-year contract. Can they do that?
Yes, they can do that.
And they can, and they still retain the right to dismiss him, but he's going to get paid for 5 years.
It's going to be governed by contract.
So they can overrule by contract what the charter says. I guess that's the question.
Yes, I think that is correct.
The answer is yes, they can.
I think that
They
is.
already have that right now.
Okay.
That's why I was asking, is because,
that's
so
light
it overrides, if he's got a 5-year contract and he's, or she is terrible, well, in this
You-
case Don,
You can convert an at-will employee to a contract employee, and I don't think that changes under those circumstances.
But I can just see a disgruntled taxpayer saying, you know what, charter says you can dismiss him in 90
Sure
days
you-
notice, and so this contract is null and void.
Sure you can, and you know what, if you want to make it abundantly clear, then you could always add in a provision that says unless modified by contract.
Okay.
So that you make it clear that in the case of a contract being in place, that it controls over the without cause.
That would probably
Okay.
be the best practice, just
I
to
actually
make sure.
think that's correct, because then you know what happens in either case and you avoid
Right.
that dispute.
Yeah.
well, we also wanted to avoid the umbrella payment for
Right.
potentially years for somebody who it doesn't work out
Right.
at the
Yeah.
taxpayer expense.
And that should be very clear in a contract how that operates, for sure. Because, I mean, like with any employee, once you switch from the at-will context to the contract context, that's what you're looking at, is what your obligations are going to be
Right.
under that contract. And it certainly wouldn't be fair to entice somebody to come to work under a contract and then say, oh, actually, we're going to go back and we're going to renege on that because we have this
Right.
charter provision.
So that's really
Okay.
helpful. So they arguably have the authority now,
But
but
it
in order
could
to
be-
clarify, it would
yeah.
make sense to say, to give them that explicit authority to modify it per written
Yep.
contract.
I
Okay.
think that's a good way of
You
putting
could
it.
also eliminate the language regarding the 90 days notice without cause and simply fall back on the state
You could also do that.
Yeah.
Mm-hmm.
So
Yes.
there's options. Yeah.
as an
Mm-hmm.
option.
Okay.
Not that I'm advocating for it.
I was going to
No,
say,
no,
of course
it's-
you'd say
It'll
that.
be too late. for me. It'll be too late.
Well, it's helpful to understand the
Yeah,
options
right.
available for sure. So.
And are there boilerplate agreements available? I think so. Yeah, I've seen them. I've worked with them. I don't know if VLCT has them, but I have them.
Okay.
and likelihood of passing charter changes through legislation. I wasn't sure if that was just a general question. Yeah, I
Just
mean,
your experience having worked in this space. And
I think it just depends on the winds of the legislature. So it's a little bit unpredictable, but I think generally speaking, as long as something's not completely contrary to public policy, it seems like things are usually accepted. But
We had some problems with our last charter, with stuff they wouldn't accept.
what kinds of things?
Things that were fairly unique that they hadn't seen in other charters. They seemed to be a little skittish if
Okay.
it's not ever been done in another charter, where we couldn't say, hey, well, Montpelier did it, so
Yeah.
how come we can't do it?
That
That kind of thing.
And that's not to say that you can't. I think that would be a basis to say if you're going to propose something that is unique, you want to be ready to explain why it makes sense and why it's lawful and why it's not contrary to public policy, why it's consistent with public policy.
So one other thing, Meryl, just to kind of put it into context, because you haven't been privy to all of our conversations. So I'll just take an example of, let's say that something applies everywhere in the state, and we were asking for an exception just in Bennington, and no one else has done it anywhere else. It would probably be more difficult to get something like that passed than something that isn't already universal across this. Take, for example, this is something that the property folks are working on. You'll see it down here. We have the lien priority situation where, you've been with us on this stuff, where we get liens on a property that aren't tax or water or sewer. The mortgage holders, et cetera, that are first in line can wipe us out. At least. And so if we just wanted to give Bennington that right to have lien priority, that probably is a big stretch, because then all the title companies, all the attorneys, Bennington's different than everywhere else in the state.
I think it's a stretch for a lot of reasons, and it's not necessarily consistent with federal law and how that operates, and just the people's general understanding of lien priority. I guess that's actually a very good example for that reason, because lenders, people who are doing underwriting, people who are making risk assessments go into that with an understanding of what the law is as a general matter in regards to whoever's first in time has the priority, unless they meet one of these very narrow exceptions. And that is probably a great example for that reason. That why would any underwriter imagine that in one town in Vermont,
right,
their mortgage is not going to have the priority that they expect? And I think there may also be federal legal
But that would have a
issues.
much better chance if it was a statewide proposition
Right.
versus
Right.
a town or even a countywide.
Yes.
Okay.
yeah,
Yep.
it alters like all of their risk calculations.
Exactly.
And then like if it was just Bennington, I imagine it would be easier for lenders to say we're not lending in Bennington.
Right.
But if it was all of Vermont, like that would be like harder for them to say we're not lending in Vermont.
Yeah, and I just think there's probably some provision of law that would prevent it. I just don't know what it is. So, and that's one I had on my list of things
To be determined. Yeah.
to TBD. Yeah.
Okay.
Similarly on that list was all of the voting questions. That is going to require some pretty in-depth research for me to give you a good response. I can tell you that you want a good response, because whatever you do, if it's different than the status quo, it's likely to be challenged in court. So you want to know what you're getting into before you get into it, and you want to know what the implications are.
And we've seen that like some of
Who's
these.
challenging the changes?
I'm not going to give you my glib answer to that.
In Winooski, it was the GOP of Vermont.
Yep.
And
Yeah.
it was
Typically the Republican.
dismissed twice.
Okay.
It was dismissed for Winooski and Montpelier, and then there's a new challenge, I think.
Yes.
And I don't know
have
if-
notes on it.
I don't know the status of it, but I need to look at that, because I want to know if it was dismissed, what the basis was, and if it's not, where it stands in the court process.
So these things are passing muster
At the legislative.
because people who are attempting to block them don't have the standing.
Correct. That's what but that's not an answer to the
Right,
question.
right.
That's the problem, is if you finally get somebody who can establish standing, then what? Is it, there's not a lot of substantive review of the actual provision yet because of that. Because the courts are taking the easy out.
Is that reason for us to not make the effort?
No. It's reason to understand what the likely outcome is and make that decision knowing that it's going to have to go through that process. And
But-
that doesn't mean it's bad. It doesn't mean you're wrong for thinking about it. It doesn't mean you're wrong for implementing it. It just means that we have a legal process
Right.
that allows people to challenge that if they believe and have a good faith basis to argue that it's not constitutional. So,
It sounds to me though that there's also then the consideration that the town would be required to defend that charter change in court, so there's potentially financial implications
Yes.
related with that.
That's what I was getting at. Yeah.
there are potentially financial implications, and when it's a purely declaratory question, that is something that is directly paid for by the town
There's no insurance
to
for it.
defend. There's no insurance for that kind of response. Insurance usually kicks in when you have a claim for some kind of monetary damage, and not if you're just asking a court to invalidate something or rule on some what they call a declaratory act, which is who's right in what this means. And then injunctive relief, which means ordering somebody to do something or not do something. So in those cases, yes, that implicates the town's coffers directly because they have to defend that. Again, that's not necessarily a reason not to do something. It's certainly a consideration.
And would you also say the same for the liens on the properties?
I don't know enough about that. I have a feeling that one's going to be more in the vein of good luck.
Come on, Meryl, give us some hope. You haven't looked at it carefully.
I haven't. You can hold out hope on that one. So then the rooms tax. At the state level, the rooms tax does apply to short-term rentals.
Okay.
But I do think that if you wanted to make that rooms tax apply only to short-term rentals as opposed to all types of accommodations that would otherwise be included in the state statute, that would have to be something you would separate out in a charter provision.
Okay.
So right now, if meals and rooms tax was on the ballot, local option tax, and it passed, hotels, motels, short-term rentals, everything subject to it.
Yep.
If we wanted something, the opportunity to just apply it to short-term rentals, we would have to spell that out, and it would have to be approved by the legislature.
I think
and then it would have to be voted on.
I think
Yeah.
that's correct.
Okay.
Right, and then it would have to be voted on.
Unless we just wanted to put in the charter that it was going to apply, but that I don't think there's any discussion about putting a meals and rooms tax in the charter, just the option.
Right.
Unless I'm wrong, the discussions haven't been to impose that tax, is to give that opportunity to
It was an option.
to the voters to choose to do that.
Well,
So-
the select board can already recommend and the voters can already
Yep.
approve that option
Right.
be exercised.
Right.
So
Yeah,
that's not a
absolutely.
charter change.
No, but it would be a charter change if we wanted to
Carve out.
carve out just short-term rentals.
Yeah,
Yeah.
yeah.
I would
Yeah.
guess the legislature would most likely not approve that.
Yeah.
Yeah, that could be. That could be. It's enough of a deviation. And
How do you follow that?
also Act
Administer that.
183.
Is it? Hasn't the legislature exercised their own 3% tax
Yes.
specifically on short-term rentals?
I was-
So we would just be doing something similar then, right?
Correct, but I think that it might be all the more reason that they don't want to have an additional burden that's only limited to short-term rentals. I'm not sure. I can see both sides of that argument, but that is exactly what I was going to say. Is Act 183, which was passed this year, imposed an additional 3% surcharge that's at the state level. So yeah, I mean, clearly they are cognizant of the ability to carve out STRs as a separate category.
The local option tax is only 1%, so you're going in with asking the state to separate based on 2 percentages, if in fact they would even buy it.
Right, you're asking for another category.
Yeah.
But I think you could make the argument like, well, I mean, you did it.
Yeah.
Yeah.
I have very little legal training.
So then the next one was the lien holder, the lien super priority question, which I'm deferring on. The next question I had was the properties subcommittee would like information on Vermont towns' experiences with adding local tax options into charters concerning vacant properties and short-term rentals.
You just a short term.
And I think I guess the question is, what do you mean by Vermont towns' experiences? Are you asking me to look at the charter provisions in other towns and see what they have in those?
Is there a standing, I guess,
Yeah,
maybe?
I think we were looking for precedent in other towns.
Is there a
in
basis?
in charters, or I mean, we're talking about like ordinances, you know, as a charter adjacent topic.
For vacant properties. So, but a local tax option specifically. I mean, when you're talking about tax, it's going to have to be something pretty formalist, you know, you have to go through a formal process. And I don't know the answer to that. If you're looking for precedent, I would need to just to know what other towns have succeeded in putting in. I can do that. I need to go through the other town charters, which isn't. It takes time, but it's not a complicated thing to do. So is that what you want me to do?
I mean, it's not that pressing to where if perhaps maybe a little direction as to where we could do that research.
Yes, I can absolutely tell you where you can do that research. On the Vermont State Legislature's website, they list all of the titles to Vermont statutes. So if you go into the statute list, Title 24 is municipal government, and then Title 24A has an appendix of all of the charters. And if you just go through and Control F, whatever your word is, it should be a fairly straightforward way to do that.
Okay.
I don't have a magical other way to do it. I can do a Westlaw search through the Westlaw tools, but it's not going to be any better.
No,
I
I
don't
honestly
think it's
just
gonna be
figured
more
you had
efficient.
every ordinance and statute memorized by heart.
I wasn't sure if you're like, oh, this is a hot topic, given the housing, or I'd heard things.
It
so.
is a hot topic in the sense that STRs are a hot topic, but I have not looked at that specific question
Okay,
among
that's
other charters. And I think the other component of that is that it's in flux right now. So you may find nothing in other town charters, but you may find a lot in getting teed up. But that's harder to research.
Yeah, the issue that I keep reading is our ordinances. Small towns, especially vacation towns, are adopting ordinances that are attempting to deal with the short-term
Regulatory
rentals.
ordinances, yes,
Yeah.
but not for tax.
But not for tax purposes.
Yeah, not for tax purposes.
One of the things, maybe this varies a little from our questions here, but that I've seen in looking into this I think it was Winooski has some regulation on short-term rentals requiring them to maintain a registry and then a licensing fee.
Yep.
But that's different than a tax,
That's
right?
different. A fee is different than a tax, absolutely. And for that reason, you have to be careful about what the amount of any kind of fee is. It has to be tied to what it is that you're charging the fee for, in the sense of reviewing an application. So it can't be so significant that it's well, that can't be what it costs to review the application? Do you
It can't be purely to
collect general revenue? It needs to be tied to whatever you're implementing as a program. So
when-
the administrative expense, essentially.
So in Winooski, one of the things they did was they have a sort of a tiered fee system where
Okay.
it's $250 for what they call an owner-occupied short-term rental, like an ADU in the backyard.
Yep.
And then the fee is $1,400 for non-owner occupied short-term rental, where it's like an out-of-state investor that has taken a long-term rental off the market and they're instead using it as an investment property.
Yeah. I could see that being challenged.
Okay.
And it's probably not enough money. I could see that let me rephrase that. I could see there being a legal challenge to that, but because of the money level that's involved, it's unlikely that anyone will think it's worthwhile to go through that process. Does that make sense?
Because the maximum that
Because-
they could recover or whatever is basically the amount of that fee?
Well,
then, or?
more because the expense is low enough that it's like, all right, I'll write the check instead of challenging this through a multi-year
Okay.
legal process.
I'll just complain about it, but I'm not going to get a lawyer.
Right, exactly. Yeah.
So,
Yeah,
so
and-
go ahead.
Just for context, I mean, we've been thinking about, types of vacant properties. There's ones that are vacant because, someone died, and then there are ones that are vacant for 10 years, and there's residential and commercial, and we know that people can make money by having them vacant based on the present tax structure.
Yep.
If you invest it, blah, 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 blah. So we need carrots in the forms of grants and, assistance and everything, and then we need sticks. What are sticks? They're, enforcement mechanisms in the forms of taxes and fees. And if you're saying fees can't be a real stick because they can only be limited to...
That's for like a regulatory fee you're charging for, say, an application or review process. There are also fees that can be associated with ordinance violations, and those can get steep. But that's an ordinance implementation
So yeah, and
process.
we have a couple great examples from BCRC of a town in Massachusetts that's vacant property ordinance is very similar to Bennington's, but it has a special sort of like fee that also increases over time of the property being vacant. But I was interested in the, possibility of a special taxation of vacant properties, because that, I think, would be, since it's in a charter, bring it to be more elevated over an ordinance and more permanent and, still optional. But
I don't know. I think the idea of a fine, a consequence for vacancy over a certain duration, if it's creating any issue, might be an interesting avenue to take. But under the current statutory structure, you would not have that authority. So that would have to be something that's done through a charter change or another legislative change. Because right now, fines are limited to whatever the fine structure is for ordinances, which is it can be a daily set amount. But if you want to deviate from that, it would have to be by special dispensation. But if you're saying that there's a Massachusetts ordinance that you could model that on, what you would be looking for then is, we would like the ability to deviate from the current fine structure in connection with this type of enforcement proceeding. I mean, I don't know how successful that could be, but it's possible. It's a possible avenue.
Okay.
Am I making sense?
Yeah, no, I think
okay.
just to make sure that I think what we struggle with, because we've talked about this long, is the persistently vacant properties. How do you deal with that when there's a financial incentive for some people not to redevelop their property? And obviously we talked about the tax, we talked about the fee. Any advice you might have as you think about this, or look at do you know of any other town in Vermont that has successfully dealt with this?
I have to say,
cetera?
probably the most advanced town in terms of having a vacant property ordinance is Bennington. So there may be others out there, but
It's not.
Bennington's is already one of the more comprehensive, if not the most comprehensive. I think the question is exactly what you're getting at, which is how do we have a better carrot and how do we have a better stick to deal with this, because obviously the tools that we have right now aren't efficiently resolving this issue. And I think you'll have to divide it into a further category of, is it the vacancy that's the problem, or is it a vacancy where the building is crumbling and falling down? Does that distinction matter? Because if somebody is just not using their building, but they're maintaining their property, it's not posing a health hazard, and it's otherwise not causing a
Not
problem,
impacting the values of properties around it.
right, then that's one thing. But if it's actually creating a health concern or a property value concern, that's a different.
We thought about that too, and we were sort of playing in this document that was sort of like a spectrum of like green, orange, and red. Green is like, yeah, someone died, but the daughter's working on the situation. Orange in the chart was like, it's been vacant a long time, which to me is not okay because it's hoarding housing and from people who need it. It's making our downtown seem like a ghost town and disallowing young entrepreneurs from starting businesses because my friend is going to other towns to open his shop, etc. So that's orange. I don't think it's like, oh, it's not, environmental liability, so it's okay. So that was orange, but then certainly red was like, it's gonna hurt somebody and like people are scared of it type of situation. So in the exercise, yeah, we were like, and in the East Hampton, Massachusetts ordinance, they spoke to that in certain ways, and I think the current ordinance in Bennington does too, and then also the first fee to be on the registry of vacant properties for a year is $500, then it doubles for the next year, and then it doesn't keep doubling, but it keeps going up.
Well, the other issue is that none of these things are self-executing, so you also have to factor in.
And that was the main point for the town.
Enforcement, yeah. I mean, because we do a fair amount of enforcement.
Yeah, we keep Merrill busy.
But the problem is we can't enforce against every single violator all at once. It's got to be. I mean, not without cloning me at least. Also, Paul and Bridget.
Well, but so that's a point is one of the other issues. The other side of the coin is the lack of human, persons available to assist with the enforcement and doing things like a registry or expanding the scope of what can be overseen. So from a fee structure, because what you said kind of just sparked an idea, which was maybe a tax isn't the way to go. Maybe a fee structure, like what is the limitations on fees beyond, like could you have a long list of fees that are, let's just say they're filtering the ability to fund the enforcement and oversight expansion.
The problem with that is twofold. The first issue is so somebody again is not just gonna open their checkbook and write you the check for the fee that they owe unless you make them do it.
Right.
And so you already got an enforcement expense and administrative costs to do that. And the other problem is you can't actually force somebody to pay without a judge saying that they have to. So you can assess fines all you want, but in order to execute on those fines, you have to go through that more complex process. For some structures, it's fairly straightforward. It's vacant because it's abandoned. So if you go through and nobody's claiming it, there's a problem of trying to locate the owner sometimes, but if you kind of know who you're supposed to serve with the papers, you could go through that process and possibly even get it. If you got a lien on it, we've done this once. We got a lien on a property and then we foreclosed on it. And that triggered a sale to somebody else who is going to do something with it. And that wasn't a vacant property, but it was still but that was the end of a long,
It takes forever, yeah.
long process.
So it doesn't solve that.
It
either.
doesn't, and the other issue is a lot of times that one, for whatever reason, the judge granted the maximum fine, which was $200 a day for like 2 years or something. So that paid for itself. But if you have an active participant who opposes that, you can end up with a $10 a day fine that doesn't pay for itself, and you don't know which way that's going to go until the end. But that's why I'm thinking maybe the idea of having a trying to justify a departure from the normal fine structure might be something worth examining.
One other idea that I've kind of been kicking in the back of my head is, like, a lot of these properties that are sort of in disrepair, that you know need to be sort of brought up to standards. Just the cost of construction is so high now, and repairs, especially, particularly for like a lot of our downtown areas, you know, that have some historic nature to them, that that the repairs could be even more expensive because of those reasons. If those repairs are made, then the property is then more valuable, and so the tax burden then goes up. So it's almost like there's an incentive not to make some of those repairs sometimes. Mm-hmm. Is there a potential to allow an owner to make those repairs and then have sort of a grace period before like the property is reassessed under?
We can do that now.
We can?
Select board has that authority. Tax stabilization.
Yeah, that's one way. And properties are assessed as of April 1. So if you make improvements to your property on May 1st,
Mm-hmm.
you're not going to get hit for that tax year.
For 1 year.
And you get, I'm sorry. You get a 1 year break, but
1 year, I mean, if the town is on the ball on reassessments, which is a different question, not a guarantee in every town.
yeah, that's true.
When we talk about like carrots and sticks, right? Like it almost feels like there's like a stick that comes with like being a responsible property owner and making those repairs, right? And so like maybe there's got to be some way to balance that too.
You know, the problem is they exist. It's just very onerous to use them because of that little paper we call the Constitution requires due process. So.
There's also equity too.
Yeah.
So I mean, if you get, your house is suddenly worth an extra $100,000.
Yeah.
Now you could, the homeowner could take some of that money and, so I mean that is a carrot to it.
For sure. I think it, for a business owner that's looking at like cash flow issues, that feels different than a residential property owner.
Yeah.
Well, the ordinance, the way that I was thinking about it is, differentiating the sticks, because I think commercial and residential is very different in terms of the stakeholders involved financially. And they're just, it's just frustrating.
I think it's a great question, and I'm happy to look into how that, because I wasn't quite sure what you were looking for with this one, and I'm happy to look into that with some more of an eye to what you've just explained, which is very helpful to me in understanding what you're trying to accomplish. We, obviously we already have the ordinance. I don't know how many registrations are happening of these vacant buildings or what the enforcement looks like. I'm guessing that
There's a few.
Yeah. So,
I think that would be helpful. And then the other sort of, opportunity we have, I think, as a committee is obviously not just proposing charter changes, but the greater report where I've heard from people like, be specific in what can't be in the charter but could be a different type of solution, to tell the select board, like, we can't change this, but you really need someone else on your staff, or you really need, like $100,000 more dollars to get a pool of, whatever the other creative solution is.
Do a few test enforcement proceedings under the vacant properties ordinance. I don't think we've ever gone through an enforcement proceeding.
Well, usually what happens is they run afoul of other ordinances, so we use those instead of the vacant property, because
Fair.
we have a lot more experience enforcing the building codes and the land use regulations than
Yeah.
we do in the vacant properties.
But if the vacant properties are vacant because of non-responsive owners, that's a short circuit, that's a default.
Yeah.
And it could yield,
But all it does is get us a building that's better maintained. It does not change the vacancy.
it could if you get a lien, if you have a judgment lien for fines, and then you go through the foreclosure process at some
Right,
point.
but if they, let's say we enforce it, they fix it up, they do the bare minimum they have to, there's no more fines.
Yeah,
Then it's still vacant and it's still not helping the community.
Yeah.
It's not adding to the vibrancy of it.
yeah.
One solution that was shot down by everyone that, because I work in, like, I used to work in, like, international human rights, where it's like naming and shaming is very powerful. I was like, we should publish all the, like, names, and then people are like, oh, but then they'll get, like, you know, like, people want to target them. I'm like, perfect, maybe that would be an incentive
We're worried
for
about
them
targeting
to...
the buildings.
Yeah, it's-
Yeah.
Well,
It's more about
Yeah,
targeting
that's
the
not a
building.
problem for me. That shouldn't be vacant.
Most of the owners, or I would say that a big problem with this that we've run into a number of times is that the owner is not here to
And
be
does not
shamed.
care.
They do not care.
Yeah. All it
It's
does
a-
is make that building more vulnerable to vagrants, et cetera.
It's some random corporation in California or
Yeah.
something, oddly. Or,
And my concern actually isn't for the building that's vacant, it's for the business
Yeah,
owner
yeah, yeah,
next
yeah.
door
I know,
who's
but
gotta
it's
deal
just
with
like
that.
Yeah.
we need significant, sincere deterrence. And like, I guess I'm biased because I do know of vacant commercial properties downtown, and I know their owners lived in Dorset and elsewhere in Bennington, and they just don't give an F, you know?
Yeah, I mean,
And it's
it's
frustrating.
hard to, you know, not all business owners are gonna be in it for the community.
Yeah, yeah. So and it's just so ironic to me that they can make money from vacant properties. It's just not in alignment with how really most, I think, of us agree that system should work. And you know, if the answer can't be enforcement, and it can't be fees, and then it can't be naming and shaming, and it can't be taxes.
well, it can
I'm not-
be. It's just it's a matter of trying to figure out ways to make that more efficient, if possible. Probably. And
So you're gonna come up with
But
an
I
answer for
appreciate,
us.
and of course, like I am like a
certainly was familiar
empathetic.
with what's inefficient.
Yeah, yeah.
Yeah.
And I'm like empathetic to the diversity of, you know, property owners that there are, and how hard it can be to get a contractor and all of that. But it's just like, there's got to be, you know. Yeah.
Something.
We'll see.
I mean,
Yeah.
I'm curious to see what, because I'm sure there are other towns in other jurisdictions that have addressed it. The other issue you have with Vermont is, unlike Massachusetts, it's a Dillon's rule state, which means any authority that the town has to come from the legislature. Whereas Massachusetts is it's called home rule, where they have their own independent authority as a sovereign. So they have a lot more ability to do things without needing the
The charter change
gen-
or
the general-
approved by the local voters.
Right.
but They don't
And this
have to
may
be
something
approved by
that
the
we
state
end up-
legislature.
If it's
So how do
in
we do
the
that?
ordinance is specific enough,
That's a
it goes to
good
the
question.
legislature, so that the state
Most states do.
changes the way it looks at
I
these
don't
properties.
know about
Right,
the
right,
numbers,
yeah.
but
That's
yeah,
fine.
it's a constitutional
Yeah,
Sounds like
issue.
we should look into
What's
that.
New Hampshire?
Yeah, we'll just change the state
Are they
constitution.
like Massachusetts?
I don't know what New
That's next round
Hampshire
two.
is. I should.
I feel like it's like a live free or die. Like,
We got 4 weeks left. We'll
the
look.
way-
Yeah,
They're like
not gonna
the
do that.
legislature doesn't have any authority, and neither
That's
does
what-
the town.
I mean, that's what. Yeah, that's why I feel like it's kind of funny.
So you get what the conundrum is. We've
Yeah.
dealt,
Yeah.
you and I have talked about this for years, and we just
I
haven't
do.
been able to crack that nut. And
Well, the other
maybe
thing-
there's an opportunity here to at least
There-
raise awareness.
There might be an opportunity here, though, to make it more painful for those people. I'd have to think about it more in that context. And then the other question that was packed in there too on transferring environmental liability away from towns, and I assume what you mean is if the town took ownership that it wouldn't be considered to be in the chain of title for liability purposes. That's a federal problem. So the EPA enforces that stuff.
Oh, okay.
So we're just SOL.
As many towns are painfully aware that and the EPA it's a strict liability statute as well, so nobody's gonna be able to circumvent that or modify that by a municipal charter.
Can you get with all the other town attorneys and file a letter signed on behalf of all hundreds of them as a as a means to change that for the towns? Is that what it's going to take?
It would take federal.
Well, that's what I'm saying.
change,
Take
yeah.
it up to. I mean, it sounds like this is a problem for people or towns and people, communities all over the country, but the federal statute is.
I have no idea how effective that would be, but it's something that could be raised with the with our Congress people. I mean, that's where you would go with that.
Yeah, right. Becca.
Yeah, I mean, I said that in jest, but I mean, it's,
I'm being charitable.
it's
You're being, yes, I think you get zero chance
Yeah.
of changing.
Yeah.
I mean, it's something to. Nobody's gonna do anything about it if you don't say something.
Correct. That's all.
So there is that component, but I don't think it's probably not a priority. How's that?
No, absolutely. And I think on this committee, like we're trying to balance, like, looking at some of these issues sort of holistically and looking for solutions, and balancing that with the understanding that here today the tool we have to work with is
Yeah.
the town charter.
No, I think what you're doing is triaging what you can and can't impact, and I think that makes a lot of sense. I totally get it. So I'll see what I can come up with that issue, and I think that spanned a number of questions. Because I think that the next question is also the same sort of idea, which is other solutions or tactics towns have used to address vacant properties, both residential and commercial. So that kind of, and as I put in my notes, Bennington actually has probably the most advanced ordinance that I
Good job.
Yeah.
Who authored that? It's a few years old.
So,
That was a Dan project.
Yeah, that was a damn project.
Well, I'm sure you helped.
I'm sure that
We just-
that I had some input, but I don't think it was. I certainly didn't come up with that idea.
Just need the select board to resource it properly.
Then the other question was, we've heard on a number of topics that would require legislative change. How is that distinct from this process, pretty much? And I don't think it is. I think that's what you're talking about doing, is asking the legislature to give you a special rule that applies locally. Maybe the distinction people are talking about is the situations where the legislature is unlikely to do that on a case-by-case basis.
right.
Right.
Yes.
So, but I mean, that is what you are trying to accomplish with charter provisions, is to depart from whatever the general provisions of law that already apply are. So it is legislative in nature because it requires the legislature's approval.
And do you have a sense if the legislature? I've heard this, that they sort of look at, like, the individual towns and the individual charters as places for some of these statute changes to sort of be tested out before they're adopted more broadly.
I could see that. I mean, it's like a marketplace of ideas kind of thing, where they're like, oh, well, we can see how it goes in this town. I mean, I don't know that that's a true impetus, but I'm sure it's a ancillary benefit to considering them.
Mm-hmm. Okay.
Is there a way to, like, one of the major considerations is obviously, as you mentioned, that there could be things that are challenged and then the town is on the hook for that. So is there, like, and not that that's a deterrent to us having our voices heard as a town, but I mean, it's a consideration for sure. So is there a way to, like, ballpark costs on something like that?
There is, but I think the other issue that you have, there's two types of challenges. There's you can't do that. It's an invalid statute challenge, which is just invalidate the statute. And then there's, you've applied this to me in a manner that has violated my constitutional rights, and I'm going to sue you for money.
Yeah, what's that one?
That could be 0 to 200 million.
Yeah, that's
Okay.
those are, sort of in the category of civil rights protections, Section 1983 actions, which usually get covered by insurance, but there's only so many times the insurance company wants to receive your notice of claim before you start having problems with that.
So this is like the world we live in.
Yeah.
Right?
Yes.
Like it could be like, I mean, I feel like in the news I just see like, wow, someone really, that's a creative one.
But I think
Yeah, like
that
my
you
coffee's hot.
you can generally assess whether something's going to fall. I mean, not with perfect precision maybe, but you can usually shepherd something into the category of maybe this will be challenged, as opposed to it's going to be in some egregious violation of somebody's constitutional rights if we do this.
So it sounds like as long as we're generally being mindful of people's constitutional rights and considering that from the beginning, then there's a good chance that we'll avoid those sorts of challenges.
Yeah, the other issue is does it actually get applied to somebody, or is it just passed and then somebody's like immediately challenging it? But if you have a change that's like people who are this color can't talk about this thing, like you are gonna run the risk of it runs a whole range, but there are some things you can readily identify as an obvious problem, and then some are a little bit more insidious where it's just more like, oh, we didn't think about that, oops. Mm-hmm. So you just want to be trying to vet those things early, where if it's untested, having it reviewed, which is what you're already doing. So
So let me ask you this then, off of the comment that you just said, in terms of voting, and I know we kind of, if we have legal residents who are entitled to the same statutory protections at the federal level and the state level that we have as citizens, how are they not allowed to vote?
that is a question for law school.
No, I'm just, right,
No,
I mean,
it's a distinction in the Constitution, because there are certain constitutional provisions that apply to residents, and there are other constitutional provisions that, there's some that apply to people, and there are
Correct.
some that apply to citizens. So it's just, it all depends on what category it falls into. And that's also why you can do those kinds of changes on a local level
Right.
that are not going to impact anybody's ability to vote in the federal
correct.
election cycle. So, because you can't change what the federal provisions are and what the federal requirements are.
And that's been unsurprising but common misunderstanding, I think, we've seen in public comments, even myself, you know what I mean, about that dynamic. It's Constitution, but also states' rights and local jurisdictions.
Well, but we pulled up the Immigration Act of whatever year it was, I can't remember. It allowed municipalities the ability to have non-citizens vote should they decide to do that.
Right.
So just from a legal standpoint, do they have that argument to say this is something that can be granted to us and it is impacting my right as a citizen, as a legal resident, to not be able to vote?
I don't know the direct answer to your question, but I can promise you that there are lots of organizations that, on the other side of the coin, that look for test cases like that, and it's probably, if it's something that could be legally challenged or legally argued, that it either has been or will be. Does that make sense?
Yeah.
Just like the people who see a provision come through and say, we're going to challenge that because we don't think it's unconstitutional, that goes both ways.
Okay.
And it happens with some regularity. I mean, with a lot of regularity. There are the lawyers, law firms, businesses whose entire
Right.
business is finding and creating test cases to challenge these types of things on both sides of the spectrum, on both sides of the political spectrum.
One question that we didn't put down, but it has been talked about regarding the age. 16, 17, one thing that's been mentioned repeatedly by both people at the public comment, but also in some of the comments submitted to us, mentioned at 18, there's a difference with the law in terms of criminality and that kind of component, that at 18 is different, which is the current voting age, versus 16 or 17.
Mm-hmm.
Is there a legal standing or anything that?
That's on my list of things
Okay.
to address.
Okay.
That was under the voting section, and I
Okay.
don't know the answer to that.
Okay.
That the state has raised the age of legal majority for certain types of crimes.
It happens. It's always in flux, right?
Yeah.
Because there's really there's arguments on both sides of that coin.
Good thing Brattleboro was first. Kind of.
Are there other questions that folks have for Meryl that haven't come up today?
When do you guys want me back?
Meryl, we're working with a pretty tight timeline at this point. We have, I think, 3 more meetings before our final recommendations are due.
So next week? Yeah.
If there's a chance you can come back next
How's
week,
your
that
Saturday
would be
evening
great.
looking?
Yeah. And we had no CPARK questions, I think, right? Apparently. Yeah.
I don't. Do you?
And who's on that committee? You?
Myself and Colleen.
Oh, Colleen. Right. Colleen.
She couldn't make it today.
Yeah, I did not hear from her.
Didn't hear from her.
Okay.
Yeah, thank you for coming.
Yeah, thank you. You guys,
Thank you so much.
great questions. It's obvious you guys are giving this a lot of care and thought, and I hope people are recognizing that, and I'm sure they're not.
The last question on the page about the elected officials swearing oaths to
Oh,
the US
I-
Constitution.
Can you explain, I'm sorry, yes, can you explain what you're wanting?
Sure. We had a public comment towards the beginning of our process. I'll just pull it up here quickly. Where somebody suggested that we have elected officials that any elected official must swear an oath to the U.S. Constitution before beginning their term of office.
That was a request for, that you impose that kind of requirement?
Yes.
I can look into that. I don't think I've ever,
Yeah.
Well, I asked you that question very quickly on the phone one day, and your response was basically, I don't think so.
don't think that you can
That
require.
we can't, it's the state law, the oath of office that elected officials is a state oath of
Okay.
office.
Right, yes,
And-
correct.
The question was, can we, as Bennington, impose an additional oath to the US Constitution that
Oh.
is not now included
I
in the state oath of office?
I didn't realize that it was a separate oath to the U.S. Constitution. I thought the question was that we talked about was, can we change the oath to a different one than what is.
It's in that context.
Okay, because I think the answer to that question is I don't think the legislature will let you do that. I think that's where
That's where we,
I mean,
yeah. But I think if you were talking about imposing a second requirement that it be an oath to the U.S. Constitution,
additional
maybe they
oath.
would let you do that. I mean, that's not inconsistent, right?
Do a oath to the charter. Just lots of oaths.
Yeah,
What other oaths can we
Yeah.
throw in?
yeah.
Oath to
I don't know.
Bennington.
That comes down to what is the legislature going to do with that, and
yeah.
it would be somewhat unique in the state of Vermont.
it would be, and I think. I mean, I always kind of think the oaths are interesting because you have to comply with the law either way.
Yeah.
So
Right.
I don't know what effect it would have, but
Well, and to that
Symbolic.
point, I'm not
Yes.
sure
symbolic. Okay,
how
fair.
how effective it would be at improving the operations of town
Right.
government. So, yeah.
It would just be one more thing for somebody to say, well, you didn't take the oath, so that means you're not really an elected official. Which is a real argument
Or
sometimes.
I think, and maybe some people would think that just that act would just elevate and remind that person and all of us of the supremacy of the
The
Constitution.
US
and how
Constitution.
it's so
Yeah.
important. Which is, it is. It is.
Could be.
I swore to it when I was a federal employee. Like, you
Could
know,
be presented and see what they say.
strong feelings.
Okay. But so not as a replacement, but maybe as an additional oath.
Maybe.
Yeah.
Yeah. I mean there's no harm in asking, I guess, is
If the committee and the select board agree that it makes sense.
right.
Yeah.
Correct.
Yeah.
And if the voters.
And then finally with the voters, yeah.
Yeah, I'm just saying it's not gonna create a problem if you ask, right? If everybody agrees and wants to present that, it's
The charter change.
what's the downs? I don't see the downside.
Okay. That's helpful. Thank you.
Yeah,
Thank
thank you very much.
So next week,
Next week.
Yes. So
So
we'll
we'll
hear
have
more about
voting and
properties and
properties.
voting.
yes, more voting, more properties, and liens. Well, I guess
That's
that goes under
properties.
properties. Yep.
Yeah, I mean, I think a lot of our conversation on voting is gonna revolve around the guidance that you
Yeah.
are able to provide us on some of this, because we're kind of at that point where we're,
Well,
we just wanna know.
It's decision time.
it's
yeah.
Just
decision time on
understand
that. Yep.
the consequences, yeah.
And that is definitely a hot topic. I'm sure there's
Which is further reason why we,
It's definitely where we've gotten most of the public
yeah,
comments,
I
right?
mean,
Yeah.
it was like,
Vast
at
majority,
the, at the in-person one, I think 5 of the 6 comments were about voting, along with all the other tangents that came off of that, and then a lot of the ones that have
I
come
mean, I
in.
think fully half of the comment form submissions
Yeah.
through the website have been on this topic.
so it's important. It's and there's room for legitimate, valid disagreement about
Yeah,
it. So
For sure.
yeah, 100%.
I think the answer is no. The town of Bennington has a code of conduct for its select board, right?
Correct.
If you're aware of any other sorts of mechanisms that have space in a charter pertaining to sort of decorum and conduct and
Ooh.
efficiency,
Decorum.
you know, I'd be curious. I think the code is obviously important and great. I can't think of anything else, but
the problem is where that comes down to is the fact that you're talking about elected officials.
yeah.
So who's in charge of
Yeah.
of disapproving of the conduct of elected officials? The voters. So that's the crux of it, and it's a point of contention. And I think our systems do presume some level of rational engagement, which is in some cases waning around the country. So
And to that point, because we discussed, yeah, they should be accountable to the voters, and to recall an elected official entails,
It's tough.
you know, a petition and a 2/3 supermajority, right? 2/3 majority vote. That is a legislative bar set, right?
Well,
That-
that's a
That's a
Bennington
charter, yeah,
town
we're one of the
charter
towns.
provision.
Yeah, that's our specific in our charter.
So it's not
So
even that like
If you
Bennington's
wanted
more
to address
restrictive
that,
in that
you
way.
could-
Bennington's
you could,
actually
through a
more
charter
permissive
change,
in that
suggest
way.
that bar be lowered.
Right.
Okay.
but that's just a revote,
Yeah.
you know.
Yeah.
Yeah,
That's just a-
Well, but yeah, but you're petitioning to recall. The question is a yes or no question on recall.
Right,
yes,
but I'm
it's
saying
based
if you
on-
lower the number, then you're just redoing, it's like, well, you're not having a field of candidates, I understand that, but you're, yeah.
Stuart, just to clarify though, when we talk about a code of conduct for the select board, there is a minimal code of conduct included in the rules of procedure, but there's not a separate and distinct
No.
code of conduct.
No,
I just
it's
want to be
in-
clear about that.
You're right, it is included in the rules of
There's a,
procedure.
and it's very,
It's-
it's not extensive, it doesn't.
No.
No, but I mean, it gets the point across, I'm just saying, there is not like a 5-page code of conduct that the select board has agreed to or signed on to, or any individual member has agreed to or signed on, except for the limited code of conduct, quote
In the
unquote,
rules of procedure.
in the rules of procedure.
And that is to the, that falls to the chair to enforce.
Yeah.
And that creates additional conflicts at select board meetings,
Yep.
as we have seen.
Yes,
Okay. Yeah, that's what I thought.
it's a,
Just thought I'd throw it
yeah,
out
that's
there.
a tough one, it is.
Yeah, yeah, no, I get it, and
It is, and it's also a tension that exists among different town roles in that there's a mix of elected officials and employees, and what is the interplay there, and then there's the also added tension of different elected positions don't have control over each other, and so it's a whole.
Yeah, we rely on the wisdom of the masses, right? Yeah.
Well, and the other problem being just the amount of time between election processes can't be so short that everybody's always campaigning 100% of the time, but it can't be so long that you have to endure something for a really long time. That
Yeah, one of the charter changes that was rejected by the legislature the last time was if you were absent a certain number of time, unexcused. We put it in the charter that the select board could then member could be removed. Legislature said
no,
absolutely not.
Yeah.
interesting.
That's a question for the voters. And that's how you get removed from office.
Yeah.
Wow.
That's interesting though, because in the Winooski Town Charter, they have a provision for if people don't attend so many meetings.
Is that
Get
select
Winooski
council
does.
members?
Council
Like
members, yeah.
elected.
Wow.
They get removed?
We can start the process, I guess. I was just reading it today, and
Maybe
I don't have it
that-
memorized, but it was like really interesting to me that there was.
Maybe it was a process where the voters get to decide, whereas ours was.
But it sped things up, I think. At least
Yeah.
it got things
Yeah.
so you didn't have to wait till the next election. It got them put off or something.
Oh, like they like would automatically be placed on the ballot or something?
Well, they get
for-
like suspended for 45 days or something like that first, and then they can put up a public hearing. It was like a whole
You fine
process.
Huh.
All
Yeah.
about the fines.
But
Interesting.
All about the fine.
I don't know. I'm just looking for.
Gotta make it hurt.
There's not a whole lot of fines to be had for the select board members with as little as that they're compensated for the work.
I know.
So then it really hurts.
They couldn't even afford to have a short-term rental in Winooski.
Yeah.
Yeah, I think the goal is just to make everything as efficient and effective as possible, and we've definitely seen some less than ideal circumstances recently.
Yeah.
Yeah, it's not any better in
Yeah, I can imagine.
through the court proceedings or anything. It's pretty disheartening.
Well, thank you again.
Thank you, guys.
We
See
will
you
look
next
forward
week.
to your
Yes.
solutions on voting and blighted properties.
I tried really hard to make that sound as no. I'm very happy. I'm very happy to be working on this. It's
Yeah,
very
thank
it's
you.
very interesting.
Much appreciated.
Great.
Thanks, Meryl.
Thank you guys.
Okay, next on the agenda, we wanted to talk about the remaining timeline that we have, thank you, for generating our final report, and collecting various submissions from our sort of research group, sort of draft submissions related to your topic areas that we could look at specific language as a full committee. Let me just grab the timeline I had here. So today is October 25th, all day. So our recommendations are due November 29th. So that means we have 4 meetings remaining after today. November 1st, the 8th, the 15th, and the 22nd. November 1st, as we all just heard, Meryl will be returning to us, so that will eat up a good chunk of that meeting. Apart from that, I think there's probably still some discussion on potentially all of our topic areas, but notably, I think on properties, voting, and CPARB. I think a lot of the governance topics maybe we are pretty near to consensus on. Maybe that's changed today. So then, sort of scoping out, it looked like on November 8th, it would be good to have sort of a first draft of our final report, including firm answers to all of the public comments that we've received so that we can agree on those as a full committee. November 15th, I'm hoping we can get to looking at a final draft. We anticipate that meeting will probably run long if there's a lot of discussion on sort of some of the details of these things. Maybe we look at meeting earlier than 3 p.m. that day so that we're not here till 7 p.m. I don't know how long that potentially could go. That also seemed like the right day to discuss lessons learned as a group so that those ideas can be flowed into the final report. And then November 22nd, which is our last meeting, would be sort of a final vote and approval on the report that we generate. So then looking at how we flow, maybe some final conversations on properties, on voting, on CPARB into that time frame. I thought potentially next week, November 1st, in addition to meeting with Meryl, we could discuss properties and voting. And then November 8th, we could discuss CPARB. And then I have a few other notes here about how we might get there, but at this point I want to open it up to thoughts on that remaining timeline, and sort of how the admin committee is sort of laid out the work that's remaining, for feedback from you all.
I personally have no problem with the timeline that you just laid out. I think it makes sense, and I mean, we got a lot of work to do.
Yeah.
But it's manageable.
All right.
So Jackie, just from the outside looking in, and since I'm not going to be submitting any recommendations, it's not relevant to me, but it's not clear to me based on your discussion when you want each subcommittee to give to, I guess, Rebecca, their draft recommendations so that they can be included in a draft report to be reviewed by the full
Right.
committee. So, and I also would want to make sure that you build in at least a week, which means on the 15th, probably, you would have something that you would want to give to Merrill for final review as far as the specific language, because
That was the other question I had here, was like, who writes like those specific charter is that Merrill that?
I think you guys do the best you can, and then we
Yeah.
get Merrill to wordsmith it to make sure that
That's
it
right.
passes legal muster.
Okay. And those would be due to her the 15th.
I'm thinking that's good, because to 20 seconds when you guys want to bless the whole thing, right?
Yeah.
And then to make sure it gets to, you meet your deadline at the 29th.
Yeah.
Obviously, that last week in November is probably not going to be very fruitful as far as getting people together.
Right.
Yeah.
Okay, yeah. I think that jives with saying that like we need to have like a final draft on the 15th that we spend whatever time it takes sort of pouring over so that we can all vote on that to be able to pass it off to Merrill.
I mean, one thing we can do, if you guys have drafts, and it's not a lot of text, we can send that to Merrill before that. You know, like if by the 8th you guys are pretty much set in what you want to do, maybe the board committee hasn't voted on it yet, we can send that up to Merrill and say, Merrill, do you see any big problems with this language?
Yeah.
And she can let us know before we spend too much time on something.
And her focus will be on the language that you want to include in the charter.
Right.
Not necessarily
not the
the
report.
entire report. And
Just
some
the
of the
specific
recommendations
yeah.
that you might want to make
Yeah.
that are not charter related.
Yeah, that's
So
not
do you
going
have
to
an
be for Merrill.
outline to the report?
Yeah. Let's plan to distribute that next week, like what we have so far. And so that will be on the 1st. What I'd like to ask is that by the 5th, can we say the 5th, November 5th, we have a first draft of the report sections back from each of our topic groups. And so
Sorry, say that again?
by November 5th, each of the groups would be responsible to have back to me the first draft of what they want in the report for their section. In looking at that, we talk about sort of our topic groups, but I want to put people's names on these things, so I thought, Mike, if you want to take a stab at writing the voting section. Carolyn Properties. Drew, maybe you can help Drew out with the governance. And I would draft the CPORB. Certainly get input from your group, but I just wanted to put people's names on these things. Any objections to that? I see smoke.
Yeah, I'm thinking. So, just so I'm clear, would it be that, like, on the 8th, our first drafts will be the opportunity for the full committee to understand what the subgroups have been doing, what their recommendation is, and then at that time, as a bigger group, we'll be like, oh, yeah, we feel like most of us are behind that, or not, or it could be tweaked. And all of that will happen on the 8th? Or on the 15th, are we doing those final, for like the longer meeting, those final adjustments as the full committee to be like, these are, where we're the, like, I like most of it, but I have this issue over here, you know what I mean? Like, are we tweaking then? Like, I'm just trying to figure between those two dates, which one we're doing that.
I think we will wind up doing that on both dates. I think that on the 8th, we'll have a chance to all look at that first report, and like any major things that somebody's like, I don't agree with this, I don't agree with this direction, whatever, we would come to agreement by vote, by whatever, that we are going to recommend this, we're not going to recommend this, whatever.
Okay.
And then on the 15th, I imagine that's going to be like more detailed, more nitpicky, more specific changes about, oh, I don't like the way this sentence is phrased, like those kinds of.
Okay.
I think that makes sense. I feel like that vote moment. We have to start working now. My mind is already like, what am I gonna write in the report based on the outline and everything. But I think that voting moment, because we established it's not like what the subcommittee or the subcommittee chair, point of contact thinks. It's what the majority of us think. So that just trigger, I think, will be important for like the record and everything.
And I would say as we draft these different sections, like be mindful in drafting that like it's not like what I personally would want this section to
It's
be.
based
But like
upon our
we've had these discussions
yeah.
before as a group, and so as best you can, I would say try to capture the consensus that you've heard in our meetings.
I don't know that there's anything that stands out to me as a major disagreement on any,
No, me
on
neither.
any of the
But
topics.
just procedurally,
Yeah.
Yeah.
I think it'd be good to have that established moment where and so everyone feels heard and clear in the yes or no.
Yeah.
I don't think we'll be unanimous in all of them.
So on the 15th, looking ahead at potentially a long meeting, is there any issues with like if I wanted to buy us pizza,
Get
or,
pizza
something, like
Yeah.
No, we'd have no issues.
You're okay.
I'm putting that down.
just
Yeah.
Put it in the.
just checking.
I'll bring cookies or something.
Yeah,
The
that
only- the
that
only-
came up in the admin group too. That
Okay.
we thought that would be a nice way to sort of dig in together.
Yeah, definitely.
Is it possible for us to have like a projector? Like I'm picturing in terms of us just like poring over a common document, maybe like you having a computer and us working there.
Yeah, we can project
Yeah,
the document.
Yeah, I like that idea.
With live sort of
yeah,
edits. and
that's
stuff.
actually the way the last committee worked. They
Nice.
projected the whole document up and did their changes and struck and underlined, because when you show your changes, generally it's shown as a new language is underlined, old language is bracketed. So you don't actually strike
Oh,
it,
I
you
see.
just bracket it, so you
Got
know
it.
it's being removed.
Okay, I see. So we might even have like two screens. We'll have like our report, because that'll include like some of our commentary, and then the charter that has like the specific changes.
Well, no, I wouldn't, well, you may have the technical knowledge to do that, I'm not gonna weigh in on that. But I think just putting your report up there, you're gonna, the committee's gonna recommend certain charter changes to language.
Yep.
And so we know that's all new. Ultimately, when it gets added to the charter, that would be a document that would probably be prepared essentially after the select board has said yes.
Okay.
So you don't need to worry about rewriting the charter at this point.
Okay.
Because if the select board says, oh, we love your work, but we're not gonna bother, then you don't wanna spend all that time.
Got it.
How does it work if, let's say, everything we submit is gobbled up? They love it. Great.
They
Do
would-
we
they would
go
probably-
back and
No, they would probably direct staff to
okay?
write the charter document so that we could place the word language on the ballot.
Okay.
Okay.
That would.
And we're gonna remember each change is gonna be a separate ballot item.
Yeah.
And their vote on it at a meeting in December.
Yes, and I'd have to review the timeline again, but the charter changes require at least 2 public hearings, the first of which must be at least 60 days before the vote. So you're in January where you're getting your first public hearing, so their work will have to be completed in December.
So so our work after we hand over our report will probably just be to attend
Attend a
those
select board
meetings.
meeting.
And make
it
a
may
presentation.
It may be worthwhile for the select board to hold a special meeting to just discuss this, so we don't get tied down with
Okay.
other business and warrants and all of that stuff.
Okay.
So that it's just the select board, you folks, and whatever audience has decided to come.
Okay.
At least that would be, I think, the easiest way to approach it.
So that'd be in December.
And that would be after we give them the report. It would just be
Yes.
to talk through any questions or be clarify
Right.
things.
Yeah.
Okay.
I mean, I would assume that you would appear at a meeting, perhaps the first meeting in December, and say, here's our report.
Mm.
And that would be in the packet if in fact it's ready to be out there the week before. So there might be some questions in give and take there, but then the select board's got to take that document and decide what they're going to do with it. And
And that report will be published on our website too.
yes.
Oh, yeah.
Yeah. I mean, their timeline is tight as well, because we're running into the Christmas holidays.
Yeah.
They're already adjusting their meetings, so their meeting, the December 23rd meeting is going to be moved up to the 16th. So they're going to compress their meeting schedule in December so as not to conflict with the holidays.
Oh,
So
okay.
it's going to be, it'll take the month off.
Does the select board meets the second and fourth
Right.
Mondays.
And in December, they'll meet the second and third.
The second and third. Oof. I'm not going to be here the second Monday. So
Okay.
maybe we'll be on the.
Well,
Visit them on the-
I'll have to look at the timeline, but it's going to be tight.
Yeah.
It's going to be, you may not be there, but Rebecca may have to take the lead.
I've been waiting.
I thought there was something going on in the background there.
That's good.
Okay.
And just one final comment, just because I'm trying to make sure everything, logistics happen and everything.
Yeah.
I mean, there's really two fundamental parts to this report. There's the formal recommendations, and then there's all the supporting information. So it would just make me feel better as we're trying to put everything together. Maybe Rebecca's totally comfortable with it, but if the recommendations were the focus on the 8th, let's get that figured out at least preliminarily, and then we can at least we know that's kind of taken care of, and then we can wordsmith the rest of it, because it's the rest of the report's important, but the primary focus of this is what you guys are going to recommend explicitly. So, and I'm just thinking, this is a lot to pull together in a pretty short period of time, so you want to make sure you get that first piece done, and we have time for Merrill to review it, etc.
Got it.
And that's just my thinking as whenever I try to pull these things together, there always seems to be things that happen, and if we spend a lot of time on the supporting documentation and not get through all the recommendations in a timely fashion, that might put us in a real bind. So
And that makes sense too, considering, we had, when we were talking through the timeline, we were gonna discuss the lessons learned on the 15th, which are part of the report, but it's obviously not part of the recommendations, I mean, as an additional part, so I feel like, right, we will still be adding to the report
Yeah.
after that 8th first draft.
So maybe we'll just schedule like a vote on like the specific recommendations for the 8th. Right. So we'll need certainly that language.
or even if it's just a preliminary vote subject to council review and final discussions or something, so everybody knows, hey, this is where we're headed, and we just gotta, all the rest of it is supporting that final recommendation.
Like a concept, but
Yeah.
I mean, I know at least voting in properties, I'm not going to speak for Carolyn, but I mean, once I hear from Merrill on some of those questions, from a personal standpoint, I'll have a much more solidified personal perspective on the direction that I would go, and I would assume, at least in how it can be presented to the committee, I would assume we'd all have a really more refined idea.
And we might have to schedule another meeting, or something if we can't,
Yeah.
It is an interim meeting or something. I don't know. I'm just. It's very optimistic to think
I believe.
it's a lot of work.
Yeah.
All right.
Yeah.
Good.
I mean, I think from the beginning we've talked about the potential for needing longer meetings towards the end or additional, meetings during this period. So, I think if folks can be mindful of that as travel plans or things like that come up, it's maybe it'll go great and we won't need to do any of that.
I'm just saying I'm fine eating pizza on the 8th and the 15th.
Yes.
If
You need to be.
I
We
will.
also-
I will sacrifice that.
Yeah.
We also have a public meeting on the 13th.
Mm-hmm.
right.
Yeah.
and that preparation and attendance, and that's just 2 days prior to
Yes.
the 15th.
Yes.
Speaking of meetings.
Speaking of the forum first, maybe. I do have some posters here that I will bring Monday to select board. But if folks here have thoughts of good places to put those up, I can give you some of those now. We did also send out the press release, or we sent to the communication coordinator for the town our press release to go to the banner next week. Do you have a copy of that with you handy?
I don't know.
I just wanted to share the quote that I included that we included in that press release because the slight departure from the quote in the first one, I think just sort of sets the tone for the second public forum. I said, as we prepare to finalize our recommendations, we want to share with the public some of the critical factors that we've considered. Changes to the town charter will also be considered by voters at the next town meeting. We're grateful for the amount of input we've received from the community. It's been a regular focus of our discussions and has deeply informed our work. We strongly encourage community members to share their comments via town's online portal soon before we complete our process. So part of my intention with that was with the understanding that that's days before sort of we vote on the final report. So I think by then, like, all of our major sort of decisions will have been settled. And so I see that second public forum more as an opportunity to provide the voters the information that we've used to make our decision, to make sure that they have that same information, because they'll be required to vote, hopefully, on many of those same changes.
I think that's really smart, and also they can come back in December for 2 more meetings with the select board on it.
Yeah.
So I think that's a perk that makes a lot of sense.
Okay.
You know, it's not over.
Right.
It's just, you know, but yeah.
Yeah. Any questions on the public forum today? No. Okay. And then lastly, select board meeting this Monday. Be presenting again. I would be very grateful if you all had the time and the capacity to show up to that, and present sort of a unified committee.
I can't attend. I guess you can't either. But
I'll be there with you.
Thank you.
I'm gonna send my husband or something.
Great. Any thoughts or questions about select board presentation?
Were you going to hold off on, like, here's kind of where we're at, and just give them an overview, or is this going to be here's kind of where we're at?
I started preparing some of my comments, which include the loss of Jim Byers that we discussed potentially having a new member appointed, and the decision we came to on that. The timeline that we're meeting with council, talking about the forum, that we're all still committed to delivering our final report by November 29th. And then, some of the motivation maybe that we've had in our conversations regarding some of the changes to town governance, right? Mentioning the distinction between like a taxpayer and a resident, a U.S. citizen, help, sort of continue to clarify, some of those distinctions that we've made. And some half-formed notes I have here for myself. And then thanks to the committee to liaisons to the public.
That's plenty.
Yeah, I think so
That'll
too.
yeah.
Yeah.
I'm just concerned about getting into the weeds, and I
Exactly.
just don't want the potential to have you dragged into like a debate where you're standing there speaking
Yeah.
for everybody, and considering several of us won't be there. I don't want you to be in that position or anybody to be in that position. I just don't feel it's the appropriate venue for that.
Agreed. Yeah, there's not enough time, the venue, and we haven't voted yet,
Right.
so.
Yeah.
Exactly.
Right, nothing's final.
Yeah, a lot of that can be guided by the chair,
Okay.
so that doesn't occur.
Okay.
Did you have something? Okay.
I was gonna say, we didn't ever ask Will if he had any public comment, but it
No.
sounds like you don't.
Oh, that's
No,
that's true. Sorry, Will.
I'll have more time, trust me.
Yeah. Great. Okay. Where are we? Upcoming agenda. I think we probably covered a good bit of
I
that.
think you were given that one.
Yeah.
Anything else that folks think really needs to be on next week's agenda?
Maybe you just want to touch base quickly on any of the slides that we went in the PowerPoint for the public forum.
Right. Right, we're having another public forum.
Are we gonna, or I guess, are we going to do a PowerPoint this time? I mean, is that the way we want to do it again? I mean, those kind of details we probably just need to touch base on.
Are we going to do it in the same format
Right.
where, like, I'll speak on voting, Carolyn will speak on housing, you'll speak on CPARB, admin, you or Drew, or miscellaneous.
Governance,
Yeah,
Governance.
governance. Are we going to do it that same?
I'm open to thoughts on that. I think that worked well the first
Yeah,
time.
I
Are we all available on November 13th?
Right?
I should be. It depends on work. If not, though, I was thinking. I mean, we can cross it if we get there. I was thinking like I could like record a video and send it in, and that could be presented. In terms of the spiel, for my subcommittee, but I can keep
Okay.
it posted.
Okay. Do you know when you'll have a firmer
Probably next
idea?
week.
Next week. Okay.
And I think that the state has gone ahead and scheduled a meeting at Kappa, Bennington College, to discuss the roundabout at Silk Road and the college entrance
On November 13th.
on November 13th.
What time
Same
is that,
time?
Stu?
I think it's in the evening,
Oh, it is.
so it would be a conflict. It may
Uh,
pull people from your meeting.
Yeah, because I want to be at that. So.
But this meeting will, that meeting, the charter review meeting will be recorded, so unless
Yeah.
people feel strongly about speaking at the meeting, they'll
Right.
still be able to see it. And
Right.
understand- and get to
Right.
see the content, yeah.
Yeah, we're trying to dissuade the state once they get their heads in a direction is very difficult.
Yeah.
They want to put a roundabout there right on Silk and the Nine?
Yes.
It's going to be,
Yeah.
it's called a peanut roundabout.
Yeah,
I thought it was
It
a
is actually
kidney.
shaped like a peanut.
yeah, it's pretty
Yeah.
cool.
Okay.
It is pretty cool.
It's already under I mean, they're already doing work on it, so
Yeah.
it's gonna start, construction's gonna start in earnest in the spring.
Right in front of the covered bridge.
Yeah.
Yep, but where that brick
Yeah.
building is,
Okay.
and the entrance to Bennington
Yeah.
College, yeah.
Are you talking about Madison and 67A where
Yeah.
they're doing that?
Yeah.
That's gonna make my life so much easier.
Yeah.
I'm just saying. It's
I mean,
an
every time I
investment
get
for
to the
me.
intersection, I'm like,
I don't have to worry
Well,
about getting
going-
T-boned?
Yeah.
at least a lot less likely.
Yeah.
Yeah.
Especially coming out
And
Silk.
Yeah.
every time you come up there, it's
Yeah.
like,
Yeah.
and then
I
if
do
somebody's
that.
coming the other way, it's like, do they get the right of way or not?
Yeah.
So,
Okay.
all right.
Okay.
Okay, great.
Good job.
Any other business?
I like pepperoni on pizza.
Great. Do I hear a motion
I'll make
to
that motion.
adjourn?
Oh, great.
All in favor of adjourning?
Aye.
Great.
Thanks, everybody.
Thank you.
Have a great weekend.
We stand adjourned at 4:49.